Now, it was a significant observation from the Allahabad High Court stressing that the unity of India is not made of bamboo reeds that will bend to the passing winds of empty slogans. The High Court made these observations while granting bail to 3 Kashmiri students who were held on sedition charges for allegedly raising pro-Pakistani slogans following the India-Pakistan T20 World Cup match in October last year. Now, the Allahabad High Court has said that the country's foundations are enduring and that unity of citizens will not bend to empty slogans. So strong words there from the court. But let's bring in some perspective here. Let me welcome our guests who are joining in at this point in time. Yashovardhan Azad, former Special Director, IB, is with us, and Zulfikar Memon, advocate, is also with us. Thank you very much, both of you, for joining us on the show. Let me, in fact, start off with you, Mr. Yashovardhan Azad. What would you take away? Because these are strong words coming from the court, but what is the, larger messaging that the court is trying to send out?
Well, the courts have, by and large, in the past also, given very strong rulings on such filing of sedition cases. And they have always said that the India's integrity and unity and the democratic strength is something which cannot be, dislodged by a few comments here and there. Sedition Act itself, I have always maintained that it should be done away with, because this is an obsolete act and it does not stand anywhere in this democracy. And I think the court has given the right message by saying this, and in a larger context, it's actually about time that we should get rid of this Sedition Act. And instituting such cases against Kashmiri students who raise a few a stupid slogan definitely, here and there, does not constitute sedition in any case. And I'm surprised how this case was even instituted by the local police.
Fair enough. In fact, Zulfikar Memon, if I can come to you here, one of the biggest, reasons for to remove this law that has been given by a lot of people is that there are enough laws, enough provisions to deal with the same internal and external threats as well. What is your opinion or your views on the other laws that exist aside from the sedition law to deal with cases, different such cases?
Avni, I must, partially agree with Mr. Azad, but in the past, on multiple occasions, I have raised my voice through your medium about the law of sedition, but it has been to a limited extent where criticizing the government also falls under that act, and that is the reason why I thought that it was too harsh, not completely with the fact that it should be scrapped, but definitely a strong amendment is the need of the hour. Given the fact that, social media is so powerful, so much freedom is given to people to emote and state what they are saying, small things here and there can be misconstrued, misunderstood, and then stringent actions are taken. So that's what is my say on it. However, in the existing matter, we have to see the whole statement of the court, the unity of India is not made of bamboo reeds. I hope this message travels loud and clear all over the country and sends a strong message to mainly the emotional driven opinions and voices which unfortunately attempts to overpower the power of law. Let us understand this very case in this very clearly. If the accused persons have been granted bail by the Honorable High Court of Allahabad, the court has really applied its mind to it. I have had the opportunity to very quickly glance the order, and I thought that the order was very fair. Having said that, we must also bear in mind that the accusations against the persons at this point of time is yet to be proved in the trial, and hence jumping to conclusions at this stage and labeling them as anti-India or terrorists, or it's a bit too premature. The court found it to be a fit case and categorically entertained and granted them bail without even dwelling deep into the sedition laws. Actually, if you see it, frankly, it's a mention that we are not going into the merits or the allegations. The court has rightly upheld the very fundamental canon of criminal jurisprudence, which is bail is the rule and jail is the exception. So this is, I think, a landmark thing, and it's a good move, great observation. As I mentioned, that if at all there is anything wrong that has been done by the students, then it is the subject matter of trial. Let the trial be expedited. Why is the state, as mentioned in the order, the trial is working at a snail pace? Why? Let's expedite the trial and come to the conclusion whether they have done anything wrong or not.
All right. Yashwardhan Azad, do you agree with that? That, there needs to be amendments to the law, the sedition law itself, and not necessarily be entirely removed? Is there anything that warrants such a draconian war to continue?
The Sedition Act is worded in such a way, if you look at it, attempts to incitement of disaffection, attempts, even that constitutes sedition. I mean, it's a ridiculously worded thing. In 1918, the United States of America during, the war was using this, and it's okay, it's fine. In an emergency, you can do that. In 1870, the British, introduced it in India. That is after the 1857 revolt. And the Sedition Act was used against Tilak and Gandhi for their attempts to overthrow the government. But it's ridiculous to use that, act now. It has no relevance, and I am firm in my belief that it should be scrapped. It doesn't have. And the way the Sedition Act is being instituted here, it's really absurd. Look at UAPA also being used in a similar fashion. These laws are not to be used like this. So I think sedition should go. UAPA Sedition should be looked into very, very carefully, and how it is instituted with the requisite permissions.
All right. Zulfikar Mehman, your view then on, what is the necessity for having the sedition law because there have been a lot of arguments about why it needs to go, as we also heard Mr. Azad just elaborate on. But what is the need for the sedition law to stay when there are other laws is the other question that is often put forth.
I mean, Avni, it's a part of a larger discussion. I don't think this is the forum to discuss that. But as I've mentioned earlier, to some extent, the applicability is the very big issue as to where it is applied. Here, clearly, definitely, if you read the law, if you read 124, there is no mention of anything that is any statement is made against the government as such, which I have been objecting from day one. Like if you bound people and if you bar people from speaking against the government, it is absolutely anti-democracy. So that is the reason why that is my objection. Of course, there are many other sections and there are many other legislations that you can curtail, that you can use in cases like this. But this is far-fetched, used and abused, and that's the reason why I feel that amendments has to be brought in place, not completely scrapped, as I mentioned, in place. But the thing is, the usability, the applicability of this section has to be very carefully applied with, considering the seriousness of it.
Yes, absolutely. And that's really the point, Yashwardhan Azad, because, the way this is used, the way charges are slapped under this law as well, is the big question. Despite of the strong words coming from courts, the past, even this particular case, as we've seen what the court has said, the message doesn't seem to be percolating in terms of where and how it needs to be used.
Yeah, I agree with Mr. Menon that it's being used very responsibly. There's no doubt about that. I absolutely agree with that point. And, for that, there is, again, like Mr. Menon said, there's another forum required for discussing this. I've written an article only recently on the police reform and how it should be made a national mission. The issue is that the institution of these cases, I mean, I don't think that any police wala, and never in my, tenure, I felt the need of instituting, sedition or UAPA, even for that matter. But when these are being instituted, I don't know who oversees that thing. There are so many layers in the police. So is it on a particular kind of a direction? Is it a political direction? And if it is a political direction, then we have to talk about the autonomy of the police. I don't think any sane-minded policeman will sort of institute a case. Somebody on a river bank, suppose, is shouting, down, down India, and somebody films him. I mean, will that be a case for sedition? This is what these idiots did. They said Pakistan, Jindabad, or something like that. But, interestingly, the defense in the case is per se something else. The defense is that we have not raised any slogan like this, and it has happened because of the rivalry of between the students. So the prosecution obviously has been able to, the prosecution side must have been trying to convince the High Court that they've come up with these slogans. And as a reaction, the High Court has rightly said that even if they raise such slogans, I mean, it doesn't mean that India's unity or the democratic structure will crack.
Yes, absolutely. Fair enough. Thank you very much, both of you, for joining us and giving us your perspective. As you said, this, of course, is a much larger discussion, but suffice to say, at least for now, very strong words coming in from the High Court on this issue.